in Islam as an ethical matter not to take on too much debt, particularly when we're talking about private consumption, the frowning, if you will, of Islam upon taking on debt for consumption purposes, and so on. So there's an interesting sort of tension there. And the response to characterize Islamic transactions in the U.S. as interest-bearing financings for U.S. tax purposes is perhaps characterized as somewhat of a disappointment by some practitioners, and in our experience by some of the Shariah scholars as well. Moving to the second point, the OCC, which federally regulates banks, has a couple of letter rulings on Islamic finance, instructing banks on how to participate in Islamic transactions without running afoul of U.S. laws, U.S. banking regulations in particular. And this has been a great development, I think, for Islamic finance. It certainly helped Islamic finance grow and happen here in the U.S. What's interesting about these letters, and I use them in the classes that I teach, is there's a discussion about form and substance in these letters. And really what the OCC comes out and says is, look, so long as you're not violating the substance of banking regulations, we're fine. So if you want to engage in a transaction that has a different form than we're used to seeing, that's okay, so long as you're not sort of cutting at the substance and the purpose of those transactions. So that creates an interesting problem, an interesting discussion for Islamic finance. Professor Moghul has talked about formalism and the literal application of Islamic law. So this is sort of an interesting. This creates sort of an interesting dynamic and some interesting questions. Should Islamic finance or should Islamic banks be banks and regulated as such? Is there another form that would be better for them? What about the division between deposit-taking institutions and investment banks? Third, we've sort of, I guess, covered this, is this notion again of banking laws and sort of rubbing and sort of butting heads here. Not sort of straight-out contradictions, perhaps, but certainly some tensions that are created that then sort of disappoint some of the criticisms of Islamic finance, that it's too formalistic, it hasn't looked after sort of the underlying purposes and so on. Now, jumping and switching gears, the idea of governing law, dispute resolution, and this is sort of my final points. Usually Islamic transactions, particularly the cross-border ones and the larger ones, are governed by UK law. That is to say, the contracts will specify that the documents are governed by UK law. Sometimes we see New York law as well, particularly here in US transactions. And of course, in intra-MENA, intra-GCC transactions, you'll find other laws governing. What we've seen in our practice is an increased interest in trying to carve out from that governing law the cases in which those laws differ from Islamic law. So you might see a provision that says the governing law is UK, subject to the glorious Sharia, or subject to Islamic principles. And you also find contracts typically selecting a court or a venue or a jurisdiction of the UK, sometimes of New York, so on and so forth, that would decide any disputes were they to arise. Now, these governing law clauses create some interesting discussions and interesting dilemmas, if you will, perhaps. First, if we're going to subject the clause to Islamic law, who's going to be the one that will apply Islamic law? Who is the one out there, if you will, that understands Islamic law, that will be able to expertly apply it to the facts of the case and to decide it in a manner that is consistent with Islamic jurisprudence and so on. Oftentimes, in the U.S. at least, answers to these questions aren't very positive. And that's not necessarily to fault the U.S. court system at all, quite the opposite. It's not the business of U.S. courts, for instance, to know and to understand Islamic law. But then if we're using clauses like this, what are we sort of looking for? What are we asking for? Are we creating uncertainty? Are we creating a likelihood of dispute? Are we creating a provision that would incorrectly be held as void against public policy? Things of that sort come to my mind, at least. The idea of venue and courts, I think probably most business parties are looking at least at the outset of the transaction, before a dispute has arisen, for fairness, for justice, for a court that they believe, for a judge that they hold has the relevant legal and financial experience to understand the transaction, to understand the party's intent, and to decide in a manner that would be consistent with that. And on sort of the lawyer's side, we're usually looking and hoping to have the contracts enforced as written. So even if you have chosen a law that isn't quote-unquote Islamic, you have created documents, hopefully you've created agreements that are Islamic, that have been approved by a Sharia scholar. And so if you're having those documents enforced as written, then hopefully that law is upholding the Islamic nature of the transaction. And again, given the broad freedom to contract within U.S. law, given the numerous parallels in Islamic commercial law and U.S. commercial law, I don't think it's appropriate to immediately characterize UK law as automatically sort of un-Islamic, if you will. Now, in choosing courts, there can be extrajudicial factors such as bias, and if you're choosing an Islamic court, then you've got to be in a jurisdiction that has one, and then does that court have the requisite legal or rather experience with financial transactions? One solution, possibly, is to utilize arbitration. And I say possibly because I haven't seen these sort of transactions go to arbitration myself just yet. But this affords the parties an opportunity to select an arbiter who has that experience that they're looking for on the legal and financial side, who has knowledge of Islamic law, who has experience with Islamic transactions, or perhaps could bring in by written instruction, the relevant experts from Sharia scholars, from those with experience that can help to explain the peculiarities and the differences of the transaction and why it was perhaps documented that way. And in hopes one hopes that would sort of control the outcome, introduce some predictability and stability, but ultimately, and perhaps more importantly even than that, increase compliance with Islamic norms, which is, after all, the very point of Islamic finance. Thank you.